Good morning, everyone. And in the last class, we discussed what are the forms uh, or the documents which will be required when submitting an application. So if there is any question, then we can look at it. If not, I'm just repeating it just for the revision purposes. Section 39 is for foreign filing license, and it is required uh, let me share my screen first. That will be it. Yeah. So foreign filing license, section 39 is a foreign filing license provision, and its purpose is uh, to ensure that defense for if any invention is related to the defense or atomic energy, a secrecy direction if there is issued or not, or whether that should be given a permission to be filed in foreign jurisdiction or not. With respect to that, the provision is that any Indian resident should take a foreign filing license if he is not applying in India, or if he is applying within 6 weeks after applying in India. Or okay, this is in general, and there should not be any secrecy direction in the section 35. Then only you can go for foreign filing without permission. Otherwise, you need a foreign filing license. Form 25 will be used here. And then form application. Form 1 is the form in which you apply. Form 2 is the form in which claims specification is provided. Specification can be of two types, provisional or complete specification. Then one application, one invention, that's the concept. Filing, then we have understood that if there is an international application, then the filing date will be international filing date will be the filing date for that international application. And the right to file can be assigned, as we have discussed. If there is assignment, then a proof of right is also required. If applicant is not a true and first inventor, then proof of right is also required to be submitted. And then there is a declaration with respect to that true and first inventor if applicant is not a true and first inventor. Section 8 statement or declaration has to be filed. This is with respect to foreign filing, and undertaking is that I will keep the controller updated with respect to whatever update is for regarding the foreign filing. If I file an application later on, this is all. Then we discuss that there are types of application, three types of application, which is normally one is ordinary, the standard patent application. Second one is the convention application, which is filed under the convention route. Another one is the international application, which is filed under the PCT route. PCT route has had two phases: international phase as well as national phase. The national phase is also known as PCT national phase application. Then there are two other criteria which are based on the subject matter, which is mainly the divisional application and the patent of addition. If what we understood is in divisional application, if there is more than one invention in an application, you can be asked to divide the application. This application will be called as divisional application. The earlier application will be called the first mentioned patent application. And if there is a patent of addition, that means there is a modification or improvement over the existing patent or applied for patent. And if that is the case, you can go for the modification or improvement which you consider can be patented. This application will be called patent of addition. Then we have then these were the documents. Form 1 for filing. Proof of right can be in form of endorsement or assignment agreement. Provisional complete specification has to be for Form 2. Section 8 statement and undertaking has to be in Form 3. Declaration as to inventorship should be in Form 5. Form of authorization, that is for patent agent, it should be in Form 26 or a power of attorney. Now, the dates in which it has to be filed is very simple. Form 1 has to be filed, that the day Form 1 is being filed, that is the filing date. Form 2, either in form of provisional or complete specification, should be filed along with Form 1. Then proof of right you can submit within 6 months. Statement of undertaking, Section 8, statement and undertaking can be filed within 6 months. And later on, Form 5 should be filed along with complete specification. Suppose you cannot file a Form 5 along with complete specification. Please note, Form 5 does not relate to the date of filing, but it talks about complete specification. So if you are filing a provisional and later on complete specification, Form 5 can be filed later. It should be along with complete specification. Suppose you have not, if you could not file the complete specification, you think that in 1 month you will not be able to file the declaration as to inventorship that under Form 5, then you can request for extension of time under Form 4. Form 4 is for extension of time. In any matter, generally Form 4 is used for extension of time. So if you are using extension for time for filing a declaration of inventorship, the extension of 1 month is generally granted. Now, form of authorization, that is Form 26. It should be filed within 3 months of the date of filing. Then, if you are then there are, if applicable, clauses. When we are talking about that, then is SME Startup Educational Institution related form, that is Form 28, along with appropriate evidence should be filed. This is filed when you are claiming this status and a reduced fee. Now, priority document. Priority document is also filed, but priority document is relevant for only in 2 conditions: when it is a convention application or an international application. In convention application, there is we refer the priority document as a base document also. The base application, the convention application, a certified copy of a priority document within 3 months from the communication of controller, if controller requires the same, has to be provided. Please note that a certified copy of priority document has to be filed. In international application, the objective is that priority document should be submitted along with PCT NP application, and within 31 months PCT NP application should be submitted from the date of priority. This is how it is. Now we will discuss today divisional patent, divisional application in detail, patent of addition in detail, and convention application. A general idea of international application also will be discussed. Okay. First, as I told you, divisional application comes in when, suppose you have filed a patent application. In patent application, as per your claim, you were for that there is only one invention at the time of filing. Later on, you thought whatever I am claiming in that particular application, it could be divided into 2 separate inventions. It could have been 2 inventions. Then voluntarily you can go for divisional application. Or if controller has raised an objection, and the objection will be that the complete claims which you have drafted, they relate to more than one invention. Since claim of complete specification relate to more than one invention, this objection will come to it. So there is only one remedy: you bifurcate the existing application. The moment you bifurcate, there are 2 applications. One, the original application. Second, the new application. The original application will be known as first mentioned application, and the second, the new application is known as divisional application. Section 16 deals with that. Now, since we are talking about an application, if you look closely, the entire thing is happening pre-grant of the patent. Either you have applied for, or it is either you got to know that there are 2, or controller tells you. Both is before the grant of patent. So divisional application can be filed only before the grant of the patent to the main the first mentioned application. Now, to remember, you can voluntarily or to remedy the objection, you can divide the application. It should be before the grant, and the reason is simple, that there are more than one invention applicable. Now, date of filing. What will be the date of filing? The date of filing, though divisional application will be filed later, but the date of filing will be deemed as the first mentioned application. The reason is simple. The moment date of filing will be different, if date of filing will be same, the novelty checks and others will be from a particular date. That priority date, if you can consider the date which is relevant for conducting in a novelty and inventive search, that will not be different for divisional application or first mentioned application. Now comes where to file. There is, in general, we understand any place of residence, any choice you have when you are filing the first mentioned application. However, that choice is not there with you when you are filing a divisional application. The moment there is a first mentioned application, the office which was mentioned for first mentioned application, that will be the office for divisional application also. What will be required? Do you require a separate power of attorney again? You will require the separate power of attorney only if your earlier power of attorney did not expressly authorize your patent, authorize the patent agent for divisional application. If it has authorized that with this respect to this patent application or any divisional application in relation to this, then you don't need to authorize patent agent separately. That POA will work. If that POA does not contain an expressly authorization for the divisional application, then yes, you have to file a new POA. Now, what about the proof of right? Proof of right, you don't have to submit if you have already submitted along with the first mentioned application. Now, how will it be examined? For examination of divisional application, it will be always done vis-a-vis the first mentioned application. Then comes the what does that mean? That we have to the examiner will try to see that inventions claims don't overlap each other. If they overlap, then there can be a double patent. So they will try that whatever you are claiming, they should be completely separate from each other, and this patent which you are separating should have the ability to stand on its own. It should be novel, inventive on its own. Similarly, so that what is happening is these will be two independent patents. So you can say it is like that. On the first file, on the date of filing, you have filed two separate patent application on that day. Request for examination has to be made for the divisional application. Now, what will be the term? Term of the filing, term of the patent or divisional application will start from the date of filing of the first mentioned application, because that is the date of filing for divisional application which we have deemed it. Then, had it been a PCTNP, had it been a PCTNP which has been divided, then the international filing date, which was the date of filing of the first mentioned application, in that case will be considered as the date of filing for this divisional application also. And the term will start from the date of filing. Then comes complete specification. See, when you are giving the complete specification, in that complete specification, you have to make a reference of the first mentioned application. This is the additional requirement in the case of divisional application. You have to tell that this complete specification is submitted and with respect and it is a division of earlier original application which was submitted this number this. And another part which is very important is you cannot introduce new substances in the first, not new substance in the divisional application. Divisional application cannot have a new disclosures. Whatever subject matter has been disclosed in the first mentioned application, it should stick to that. So that means that you should not create an entirely new patent application. It should always based on the first mentioned application, whatever disclosure was there, that should be this should be under the scope of that first mentioned application disclosure also. Now, claim of divisional application. If you are making a claim based on the claim of first mentioned from which instance is divided, it should always be based on the first mentioned all the claims which have been mentioned in the first application. Now, you cannot add any claim which is outside of the earlier claims. See, this is like that. I claim something within a boundary A, B, C, D. You cannot now introduce E. It should be in the boundary of A, B, C, D only. The only thing is it will be ABC or BCA, whatever, how you have divided the invention, so that they don't overlap. But it cannot be in such a way that what was claimed earlier, now you are claiming something more than that. The first mentioned application and divisional application may be amended upon requirement, direction of controller, to ensure that neither of the complete specification includes a claim for any matter claimed in other. That is to avoid the overlapping. There should not be an overlapping. What is claimed in one application should not be claimed in other. Now, there is one question whether a divisional application is a substantive application. Yes, divisional application is treated as substantive application because separate fees required to be paid. All fees applicable to the patent application shall be paid. Once allotted, it will be an independent patent. Separate request for examination is made for this, and it can be prosecuted separately. It results in the independent patent. That means if suppose you have bifurcated, there can be a thing that first mentioned application is not getting granted, but divisional application is getting granted. So the non-grant of this will not non-grant of first application will not affect the divisional application. Both will be independent, prosecuted independently, and will give you a different a right independent to each other. Now comes the priority. Priority, as we have mentioned, that first mentioned application's date will be the date, and so all the claims of divisional application will have the same priority as that of first mentioned application. Divisional application is, again, this is a repetition, that divisional application examined vis-a-vis first mentioned application, and this is done to avoid any overlapping which can result in a double patenting. So the concept of divisional application, always remember when you are talking, you are answering the question of divisional application, use the terminology first mentioned application and divisional application, not earlier application or any other thing, or base application. Don't use the terminology because those terminology are restricted other kind of applications. So first mentioned application and divisional application, this is the terminology you will use. And remember, divisional application is as good as an independent patent application in all sense. It will be given a different, you will get a separate patent certificate, and when you get a separate patent certificate, your renewal fee will also be paid for both patents. One is first mentioned application patent which has been granted, and divisional what has been granted. This is a simple bifurcation of one application into two, and both exist without depending on the other, except that the date of filing is considered same for both. Now, patent of addition. In patent of addition, what is happening is, suppose when you applied something for an invention and you thought this invention, there is something how this invention can be improved upon, or a modification of invention which you have done in the first in the application you have filed. If you want to go for patenting this invention, you can go for this addition. This is considered as a patent of addition, that is modification and improvement of an invention which is already disclosed in one application. Now the main application will be considered as the first application which was filed will be considered as a main application, and the new application will be the patent of addition. This patent of addition, so simple. The moment I'm talking of patent of addition, that means there should already exist a main application, and a patent of addition can be filed on the same day or subsequent day of filing of the patent application of the main patent. And the date of filing will be considered date of filing of the patent when the patent of addition application is filed. Here, there will be no deeming provision as it was in the case of divisional. The day you file, I will consider that will be the date of patent of addition application. Now, I said that first mentioned application and divisional application, in the case of division application, will not be related. Right, they will be prosecuted separately. Here, what will happen is, since it is an improvement of an invention, then the patent of addition will be granted only after the grant of main patent. Once that patent is granted, then only patent of addition will be granted. Now, there can be a scenario where you got a patent, but somehow you know that if it is getting challenged or there is some other problem, the one patent is nothing but an improvement of earlier patent. Then you can get it converted so that your improvement of patent does not get invalidated in any proceeding. So the conversion is also allowed. You can convert if you have two patents and your one is nothing but an improvement of the earlier of the other patent. Then yes, you can ask for the conversion of the independent patent, one of the independent patent, to become the patent of addition of the other. Now, this is the life is also dependent on main patent. If main patent fails, patent of addition will expire. The patent of addition expires along with the main patent. So since my life is dependent on the main patent, my renewal fee is also not there. You don't need to pay a separate renewal fee for the patent of addition during the term of the main patent. If main patent is existing, you don't have to pay any renewal fee for the patent of addition. However, suppose there is a chance that the main patent is revoked. If main patent is revoked, the patent of addition may be converted into independent patent, if so requested by patentee, and the renewal fee for the same could be paid accordingly. So there is only one condition, that is when main patent is getting revoked, that patent of addition can survive on its own. Now, we'll talk about how the examination of patent of addition is done. The novelty and inventive step, when we are looking into the novelty and inventive step, what cannot be challenged is that lack of inventive step with respect to the main application or patent. Because anyway, since it is an improvement, the teaching will be available there. So lack of inventive step with respect to main patent will not be a ground for challenging it. However, novelty is necessary. Even if it is an improvement, novelty should be checked, and it should pass the novelty test. It should also pass the lack of inventive step with respect to other documents. Exception is only main application, nothing else. Preference, same thing as in since they are the complete specification will also of application for patent of addition shall include the complete specification of will include again the specification of the number of main patent or application for main patent. Then a definite statement has to be provided that this invention comprises an improvement or modification of the invention claimed in the main patent, which has been either granted or applied. Okay. So we understand patent of addition. Now, just to recap, please remember and don't confuse. Section is very easy to remember when I'm talking of patent of addition. It's 54 to 56, 3 sections dealing with the patent of addition. Section 16 deals with the divisional application. So you can remember 55, there was existing 5, and then you went for another addition of 5, that is 55. So a prior or later, both sections are deal with the patent of addition. So 54 to 56 deals with the patent of addition. You can make this kind of correlation or connection here also. Okay, once again, I'm repeating, divisional application is because of division, while patent of addition is by filing a separate application for any modification or improvement. In divisional application, the earlier application is called as first mentioned application. In patent of addition, the earlier application is called as main application. In divisional application, both the applications are treated as separate application, and they will result into the independent patent grant. And there will be separate requests for examination and other things. While in patent of addition, it is dependent on the main application. Main application of main patent. If main patent fails, main application and it cannot be granted before the main application patent is granted. However, and in divisional application, the patent which you are getting, you will be renewed on its own. While here, if the main patent exists, the main patent will be only renewal fee for that has to be paid. Patent of addition will not require for any payment. Now, while examining the divisional application, in examining the divisional application, care will be taken that the first mentioned application should not overlap with the divisional application. While in this, when we are going in this, we will see that whenever we are checking the novelty, it should pass. When we are checking the inventive step, the only document which we will not be using is the main application. Rest, every check will be there. Once there can be a situation where main application fails, main patent gets revoked. If main patent is getting revoked, then patent of addition can exist as an independent patent. Okay, so these are the difference. That section 16 deals with the divisional application, and 54 to 56 deals with the patent of application, patent of addition. Sorry. Now we are talking about these were the general, and it can happen. A divisional application and patent of addition can happen in all 3 forms. An ordinary application can go for bifurcation, or an improvement can be filed for that. Same can happen with a convention application or international application. See, when we are talking about the ordinary application, convention application, and the international application, the only thing which we are basing our division is that one is directly filed in the IPO, another is filed on the basis of some other application, or taken a route of PCT, Patent Cooperation Treaty. If it is coming through Patent Cooperation Treaty, then it will become an international application. Now, convention application. Now, what is convention? Every time a convention comes. When we were discussing the history of patents in our first class, I discussed that we became a member of WTO agreement and Patent Cooperation Treaty. The year is important, it can come. India became a member of WTO agreement in 1995 and PCT in 1998. Okay. Then Paris Convention is actually an understanding of 1883, very old. And it talks about reciprocity in filing with right of priority. That means reciprocity, which we have said that if your national is not, if my national is not getting discriminated by your country, I will not discriminate with your national. This is the reciprocity. Right of priority is that if in certain period you file in my jurisdiction, I will recognize the right of priority. That means I will check your novelty and inventory with novelty and inventory with respect to that date of priority, so that the existing base application which is earlier filed should not become a ground for rejection in my jurisdiction. Okay, so India became a member of Paris Convention in 1998. So in 1998, we went into both P. Both P we went into in 1998, Paris Convention as well as the PCT, both in 1998, and in WTO 1995. Okay, there is another Budapest Treaty. We have discussed it. The Budapest Treaty is on the international recognition of deposit of microorganism for the purpose of patent processing. Budapest Treaty. What happens is if you are patenting something with microorganism is getting patented, then you need to deposit it to a certain depository which have been recognized. So it provides a mechanism for depositing biological material, any biological material in the internationally recognized depository authorities for the purpose of supplementing the description of specification. See, what we considered, if there is a biological material, so it might not be feasible for completely describing the entire biological material. So we deposit a biological materials, it becomes a full disclosure with respect to the specification which you are submitting. Okay, so India became a member of Budapest Treaty in 2001. Remember, 95, then 3 years 1998, then 3 years 2001. First is WTO, then Paris Convention and PCT 98, and then Budapest Treaty. Please note, if you forget, it is in reverse alphabetical order. First W, then P, then B. Okay. What is convention country? Any country which is signatory to a party or a group of country, union of countries or intergovernmental organization which are signatory to any international, regional or bilateral treaty, convention or arrangement to which India is also a signatory will be considered as convention country. That means it's not what we are generally we refer to convention countries, whoever has signed the Paris Convention, because maximum people have signed there. However, if there is an international, if I have a bilateral treaty also, and we have agreed for IP protection, then that can also be considered as a convention country. So international, there can be treaty on international level in which many people have signed, many nations have signed. There can be a regional. Regional means, for example, ASEAN. Any agreement between Asian nations can be considered as regional because it is related to the Southeast Asian nations. Okay, or African, in Africa region, if there is a treaty with respect to Africa region, or Latin America, that one, or Europe, that is also EU is a regional treaty. Bilateral treaties, India, Pakistan, India, Bangladesh, India, Nepal, that will be considered bilateral. Only two parties are there. So it can be a treaty, it can be a convention, it can be arrangement, whatever. If that is the case, we will consider that country as a convention country. And in that convention country, what is important is that if one country is giving similar privilege to their to my citizen or their member citizens, what they are according to their citizen, then that is a convention country for this purpose, and India will reciprocate the understanding. I will reciprocate the similar privileges to their citizens. Now, at present, India is a member of WTO and member of country that we have discussed. Member country of Paris Convention, contracting state to PCT. Any country, union or countries or intergovernmental which are member contracting above convention, treaty, agreement or convention countries for the purpose of that means even by PCT, if you are under PCT also, then also we can consider you as a convention country because that is an international treaty. Now, convention application. What is a convention application? Where a person has made an application for a patent in respect of invention in a convention country. If you have filed an application in a convention country, that will consider as a basic application. Now you have 12 months. Within 12 months, if you apply in India, your priority date of claim of that complete specification. Okay. So I will consider the date of that basic application as the priority date for this, my application. That means if you have filed in US on 1st January 2020, so you have to file before 1st January 2021 in India, so that you don't lose the priority. Otherwise, what will happen is this will become a separate application and the priority will be missed. And this application will be considered as a domestic application, will become a domestic application, and the convention priority will not be helpful for you. You will lose the priority. Okay. Now, where applications have been made for a similar protection in respect of an invention, and now there can be a situation that you have filed in US, you have also filed in Europe, in Germany or France or UK, and then you have come to file to us. Then how will I calculate? I will calculate from the earliest application. If you filed first in Germany and then you filed in US and UK, then I will take my 12 months calculation from the first filed application that was in Germany. Okay. Please remember, on basis of these things, questions will come. MCQ also comes. Even the descriptive can also come. So now, on the case basis, this kind of question comes. This convention and international application part mainly dealing with the priority date and filing date. This is confusing for people, and hence you can expect questions from here. 2 or 3 questions generally can come. So sometimes it is on case basis, you have to advise. Sometimes it is basis of the MCQ, or sometimes it can be multiple MCQ that these 3 are correct for this particular application or not. But it is always a use-based case which comes under convention application or PCT application. Nothing direct will come. That's how I have seen that nothing direct comes. When comes now the third part. First we said there should be a base application. It should be in a convention application, application country, convention country. If there is a convention country and it has been done, now within 12 months you have to file. One scenario clear. When it has been filed within 12 months, I will consider the date of filing of base application as a priority date for this application. This was the first concept. Second concept was, if the patent application is filed in more than 2 or more convention countries, that means there are various base applications, then what I will consider is the earliest one as the base from which 12 months should not have been passed. Okay, you cannot fall on the US, the latest one, for calculation of the 12 months. You have to fall on the earliest one for calculation of the 12 months. Now the third part. If the application which you have filed, there are 2 or more inventions which are cognate. Cognate means related or connected, or of which one is modification of another. Okay. So if that is the case, you think that it depends, since a jurisdiction, every jurisdiction has a different standard for patenting. So there can be that there can what their other people are considering two or more invention, we might be considering only one invention. So if that is the case, and you understand that this can be a problem for getting a patent in India, you can file a single convention application. But if there are two or more inventions, we will again fall back to the earliest of the said application. See, the B and C point is different. The earlier one was that there are two applications there are two applications that two or more convention countries. Now what we are talking about is that the application for protection have been made at two or more invention. And if they are related or a modification of it, you can claim the same in one single convention application in India. How the priority will be considered? We will consider the earliest date of the said application as a date of priority here. Now, if you have combined two or more invention into single convention application, please remember we are still following the concept of one invention, one application. What we are saying, they were related application. They were related application, and you have tried to do it in one go. Okay. So this is a single invention which is based on your earlier two inventions which you have claimed earlier. So the question is two. The fee will be paid. A separate fee will be paid for. Paid as if you have applied for both inventions, because you are falling back on two basic applications where this is related. So that's all. Okay. Now, document to be submitted is every convention application shall be accompanied by a normal complete specification should be there given. Then you have to specify date on which the first of such application was made and the convention country. That base application details have to be mentioned. You have to also give me a statement that you have no application for protection in respect of HMM. So you have to tell that no other application is pending, which there is no other existing base application which has a earlier date than what you are claiming here. So no application for protection in respect of invention has been made in convention country before that date by the applicant or by any person from whom he derives the title. Now a complete specification filed with convention application may include claims in respect of development or addition. This is what we have discussed in the third point, that development of addition or invention you can include always. However, the applicant should be entitled as a true and first inventor or assignee or a legal representative of a deceased inventor. That is what section 6 is talking about. Now it says that there has to be an abstract. Then a certified copy of priority document should be communicated to controller within 3 months from the date of communication of controller of such a document. If controller says that share their priority document, a certified copy of priority document, you have 3 months to share that certified copy of priority document with controller. Now, another problem which comes in the convention application is that application may not be in English or the language in which we deal with. So if it is not in English, it has to be accompanied by a translation, verified English translation of such document. The priority document should be translated and then submitted to us. Now, it says that there can be an existence of multiple priorities. That means there are 2 or more applications for patent which are constituting one invention as per the Indian law. So, but they have been filed in 1 or more conventions. The one application within 12 months from the date on which the earliest of those applications disclosed disclose the application, complete the basic application. So now how we will determine the priority. What we will do, we will check the claim of the priority date on the basis of the basic applications, and the first disclosure, the document which first discloses that invention, that will be considered as the priority date for this. Okay, it might be confusing at present when I'm teaching you. Please go through it. If you have again a question, you are again once you have gone through this entire provision, if you still have a doubt, then we will discuss it in the next class. At present, multiple priorities can be confusing, so let's go with the flow. If you have a confusion, we'll discuss it in the next class. Now comes the term of the patent of convention application shall be 20 years. From which date? Date of filing of application in India. So that means the benefit is what? You are getting the 20 years, the 12 months, your priority is also getting saved, and you are getting the entire 20 years. So convention application is helping you there. A convention application can be divided, and same thing we have said, if it becomes, the moment convention application gets divided, become a divisional application of convention application, and the priority date will be the same as of the convention application. Now, a convention application shall not be post-dated under subsection 1 of section 17. See, but to a date later than the date on which the application could have been made under the program. Simple is 17.1 deals with the post-dating. Post-dating is in simple, I have filed an application on in January 2022. However, I want to post-date it. That is, I can go below and say that my application, let it be post-dated and in April. What I am doing here, I am changing the date of filing actually. But the moment I change this, what is the problem I am facing is, what I am losing is, I am losing the priority. I am making the moment I come back in this 5 months, if I am delaying this, post-dating this application, I am exposing my invention to the all those inventions, all those publications which have been published during this 5-month period. So this is a risk which I am taking when I am post-dating it. So now they are saying a convention shall not be post-dated. So that means, suppose there is a 12-month window from the earlier month. If you post-date, it will, if it is crossing this 12-month window, then we will not be, this post-dating will not be applicable to you. We will not let you post-date beyond 12 months. However, suppose, so let's understand it as an example. What we are saying is, suppose there was an application of 1 January 2021. You had the time to file the convention application by 1/1/2022. Suppose you filed it in April, that is the 4th month. So under 17.1, you can post date it for 6 months. So if I am post dating it for 6 months, so it will become 10. It's still in the boundary of 12 months. So it will be acceptable. However, had you done the same thing, had you filed the basic the Indian application on the base of basic application in October, then post dating cannot be beyond the 1st January 2022. This is what it means. Now, the key points which you have to take is that application should be from the member of convention country, and the principle of reciprocity is the basis of this particular law. First application of patent should be filed in a convention country, which will be considered as a base application. Within 12 months of the base application should be filing should be done. Date of filing of base application will be considered as a priority date. Term of patent will start from the date of filing of application in India. Divisional application can be filed and a convention application can be post-dated under section 17, but not later than the 12 months from the date of basic application. Or base application. It's the basic application is incorrect. Should be the base application. So we have understood the convention application. Now we are talking convention application. Within 12 months, I have to file. Then there is an international patent application that is filed under the PCT. I'm submitting a PCT, I'm just showing you a PCT diagram, how the PCT system works. In general, there is, when there is an invention, you can file an international application with the receiving offices. What is a receiving office? Receiving offices are those jurisdictions which are entitled to receive the PCT applications. You can directly come to International Bureau related to WIPO. You can directly file there, or you can file with the receiving offices. India is a receiving office. Delhi office is considered as a receiving office. And in US you can file. US is also a receiving office. Germany also has a receiving office. Depending on this, where the receiving offices are, there you can file the international applications. Now we have an invention, which are the object of international application. They are filed with the receiving offices. This receiving office transmits the application to WIPO International Bureau, which carries out the search, prepare the written opinion, and transmits the reports to WIPO. So there are international search authority also. Okay, so International Patent Examination Authority or International Search Authority. These are international authorities which carry the searching. So these will give you a search report. WIPO International Bureau will publish it on the patent scope, that is their site, and this will WIPO will communicate this to the designated offices which you have chosen, where the patent should be granted with this. So there are simple. There is an international application. It is filed with a receiving office or international bureau. Once it is filed, they will be published, and it will also be communicated to the designated office for the prosecution as per their domestic law, and patent can be granted if it is found that they qualify for getting the patent as per the domestic requirement. Now, this is a flow chart. See, then how can you file an international patent application? See, in international application can be filed in two ways. Either you file in India, and on basis of this Indian application, you take a PCT route, or you directly file an international application with RO or International Bureau. Now, the thing is, the moment you decided that I will not file an Indian application, I will file an international application. This international application will be treated as a foreign filing, and you need foreign filing license under section 39. Now comes international application. First is, this is when there exists a local application. You file a local application, is typically a national patent application in the home country of an applicant. Okay. This is a 0-1. This is the starting. Within this, you have 12 months to file a PCT application. Remember, convention application also have a 12 months. Now, after 12 months, an international search report and written opinion from the date of the priority claim, which is the base 0, From there, 16 months, within 16 months, international search report and written opinion will be given. And then by 18th month, from the 0 month, that is the date of filing of the local application, international publication will be done. Remember, 18 months for the date of publication. This is similar to what is in India. So 18 months takes for publication. Once it is published, you can always, there is one search which they conduct and they provide their written opinion. You can always ask for a supplementary international search or also request for international preliminary examination. If you ask for international preliminary examination, this will be a report on the patentability of the invention which you are claiming. However, this is not binding on anyone. Same thing will happen with the supplementary international search report. This international search report is for your benefit. You can understand, watch prior arts are there, and if you want to amend your international application, you can do that. Now, then on the expiry of 30th month or 31st month, as the case may be, this application can enter into the national phase. Now, PCT application can also be filed without filing a local application. As I said, there what will happen is only one thing is going to miss, that is 12 months. You have an international application and you have 13 months to enter anywhere. Now, question comes very easy. I didn't file in India. Can I come back to India as a designated country? Yes, you can. So you file an international application as a PCT and come to India via following the 31-month route. You can come there. Okay. Now, there comes months from the priority date. This is also a timeline. It only says international phase starts from the date of filing of the PCT application and goes to the national phase, which is the 31 months in India from the date of priority. Okay. Now, international phase. In international phase, a priority claim based on any earlier filed application in any member country of Paris Convention, you can claim a priority. This is the international phase. In this, date of receipt of application by RO or IB will be considered as an international filing date. What are the 4 main steps? First is the filing with the receiving office, filing of international application with the receiving office and its processing by the receiving office. They will see whether fees has been paid properly or all the other formalities. Then an establishment of international search report and a written opinion by international search authority. This is the international search authority will give you an international search report. Then there will be an international publication within 18 months. And it will get communicated. This publication will be communicated to all the designated and elected officers. Where you have designated, suppose you have designated India, Japan, Germany, France, then this international publication will be communicated to these designated or elected officers. Now, International Bureau will publish only after the expiration of 18 months from the priority date. The published international application contains the full text. So what is getting published is what the application you have filed, international search report, and any amendment of the claim filed by the applicant. This is what is getting published. Then, as I've discussed, an option of international preliminary examination is there. You can opt for an international preliminary report on patentability will be provided. However, this report is non-binding. It is only a preliminary opinion. In what are the important terms with respect to this? Receiving office. What is a receiving office? This is a national office, intergovernmental or international organization with which the international application is being filed and which checks and processes it according to the PCT and its regulation. This is called receiving office. And receiving office Can you approach any receiving office? No. In PCT, there is a requirement of nationality or residence. If you are a national of that country or you are a resident of that country, you can file with that RO only. For example, you cannot file, an Indian cannot say, I will file in US via PCT route. You cannot file that. Reason is simple. You are not a national, you are an Indian citizen and you are not residing there. However, in NRI residing in US can file a PCT because he will take a plea on the basis of residence. Okay. Now, receiving office determines which office is competent ISA. So receiving offices have a list which they consider the ISA. The applicant can choose if there are more than one competent ISA. There are various ISAs. There is a list given. You can go in your patent manual and read it in very simplified manner. All this in more detail. Designated country, a contracting country indicated in the international application where invention is getting short, that is the designated country. That is, if I want an patent in India, then it becomes a designated country, Japan, France, or whatever. If I've designated this, that means I'm aiming for getting a patent in those jurisdictions. Those are designated country. International Bureau is the is a part of WIPO. In addition to it acts as a receiving office, as well as it also process tasks with respect to the international application with all the receiving offices worldwide. So it can also act as a receiving office, as well as it also receives application from other receiving offices. That is what International Bureau is. Then there are three types of fees. First is the transmittal fee. What is a transmittal fee? Transmittal fee is for receiving office. They transmit the document to the IB. That is a transmittal fee. It is not required. If it is online facility you have used, then transmittal fee is not required. Then comes international filing fee. Same thing. It is for the benefit of international bureau and paid to receiving office when filing an international application. So receiving office will receive both fees, and that's how your transmittal fee and international filing fee will be paid. Then comes search fee. Fee for the benefit of international searching authority for carrying out the international search and other tasks. This fee is also paid as receiving office. The receiving office will ask you for transmittal fee if it is offline filing. If it is online filing, transmittal fee will not be there. There will be international filing fee. That will be paid to international bureau. Receiving office will receive it. Then comes the search office, search fee. That will be paid to the international searching authority, which will conduct the search. So this fee has to be paid. After expiry of 31st, PCT NP is filed. That means in designated country, when you enter, a separate application has to be filed based on your international application which you have filed. Now, this PCT national phase application has to be filed within 31 months from the priority date. Please remember 31 months from the priority date, not from the date of filing of for the earlier application. Second, PCT NP shall be filed in the form 1. Same thing, form 1 we are filing. Here, international filing date will be deemed as the date of filing in India. This we have already discussed under section 7. Then comes international filing date allows preservation of priority from date of filing of first application in the convention country. Correct? You are saying, see, the base application is in US, but PCT was filed 12 months later. So the priority is still there. Then comes applicant may delete a claim without filing an application for amendment. So deletion of a claim in an international patent application will not require an amendment, application for amendment under Rule 21. Amendment in international application, if you have done before ISA, IPA, okay. If before entering in national phase, you have done any amendment in international application, then we will consider it as an amendment if you desire. If you say those amendments should be considered as amendment in the patent application for India, we will consider them as an amendment in patent application for India. So this is the type of application. This is the entire spectrum in which this is done. Please read, go through the relevant sections and rules related to these applications, as well as the patent manual. If you read the patent manual, it is very simply written. You can also go to this PCT FAQs just for a general understanding. Don't go for entire thing, just for a general understanding and the questions. What is happening, how Paris and PCT routes, and what are the benefits of PCT process. Okay, this is what it is given. What is benefit of international patent examination? Just for your sake of your understanding and a general reading, you read it. Okay, I'm just sharing this link here only. In documents also, as well as WhatsApp also. You can refer it for your benefit. Okay. This is all for today's session. I will be stopping the recording.